All set? Committee will please come to order. I would invite you to join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Can I get a motion to go into executive session?
Second.
Moved by Senator D'Alessandro, seconded by Senator Gaida. All those in favor of going into executive session say aye. Aye. Opposed, nay. Ayes have it, motion carries. First bill we'll be taking up is House Bill 1587. Senator Hennessy moves ought to pass on House Bill 1587. This is relative to determination of average final compensation under the retirement system and making an appropriation. Is there a second? Second by Senator D'Alessandro. Discussion. As I understand it, what this does, it brings a group that were not considered years ago up to parity on the way that their retirement is calculated. Seeing Senator Hennessy.
Thank you, Mr. Chair. My understanding also is that by funding it the way we're funding it will not increase the unfunded liability of the fund.
Thank you. Any further discussion? Seeing none, all those in favor of the ought to pass motion say aye. 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 Opposed, nay.
Nay.
And the ayes have it. Motion carries 6-1. And Senator Hennessy will take it out. Okay, House Bill 1417. Sorry, I've got a long list of things. They're mixed up. Never mind. Fifth. Thank you. That was it. 1535. This is relative to a one-time allowance for certain state retirees. Senator Reagan moves in expedient to legislate. Is there a second?
Second.
Second by Senator Gaida. Discussion. Seeing none. The motion is inexpedient to legislate on House Bill 1535. All those in favor of that motion say aye.
Aye.
Aye. Opposed, nay. The motion carries 5-2. Senator, I'm sorry? What?
I voted no.
You voted no, okay, sir. The motion carries 4-3. The Senators Morse, D'Alessandro, and Rosenwald opposed. And I'll take that one out. Okay, let's back to 1547. Senator Hennessy moves ought to pass on House Bill 1547. That's seconded by Senator Rosenwald. This is relative to perfluorinated chemical remediation in soil and procedures for certain hazardous waste generators. And it's open for amendment, and I understand there is an amendment on this. You should have in your binders at 1815S.
Subsequent one, right, 1931?
1931S.
1931S.
I'll move the amendment.
I'll second it.
Okay, Senator Morse moves Amendment 1931S. That's seconded by Senator Gaida. Discussion on the amendment.
Senator Waters and Carson are offering the amendment. It's to put $25 million back into the PFAS fund. We got a notice from the department that the first $25 million has pretty much been allocated. And we're going to be gone for a little while here, and there's certainly more projects. I mean, the commission is here if you need to figure out. We'll go through another $25 million, I think, fairly quick.
Okay, further discussion? Seeing none, we're voting on the amendment 1931S. All those in favor of that motion say aye.
Aye.
Aye. Opposed, nay. The ayes have it. Motion carries. Open for an amendment on ought to pass as amended. Moved by
Second.
Senator Rosenwald, seconded by Senator Gaida. Any discussion on the bill as amended? There being none, all those in favor of the motion say aye. Aye. Opposed, nay. Ayes have it. Motion carries. And I'll take that one out. Okay, I see that Representative Hunt is here, so let's go to House Bill 1503.
Thank you, Mr. Chairman. I'm sitting in for Representative Ammon, who is the sponsor of this bill, but unfortunately he had a very serious car accident and will not be able to be here. But I'm more than willing to step in.
Thank you for stepping in.
So I have a little speech I can give you guys ahead of time, because I realize that whenever you get a 50-page bill, you might be a little shocked.
It got us lots of sleep last night.
I'm sure you've all stayed up all night reading it. So I guess I would start out by first telling you that as much as people might think this is a crypto bill, this is a what I would call a Uniform Commercial Code legislation. So UCC, most of us probably the only time we've ever stumbled into UCC is we go lease a car, and they make you sign a UCC form. And but UCC is actually much more than that. UCC is the standard. The whole process of UCC is that this is legislation we want to affect the entire country, but we're not going to do it federally. We're going to do it by each state. So every state will enact this legislation. UCC, there was 1 through 9, and then I don't know what happened to 10, 11, so this is actually UCC 12. I think that they were maybe playing with something and they decided not to go through it. So UCC is a group of lawyers that are in Chicago, and we actually have representatives here in New Hampshire that also represent the UCC, but that the actual Congress who come together to create this is out of Chicago. And the goal is to standardize what some of our very common commercial activities, all commercial type law. And so that they're standard from state to state. And I would say is that they've done a very good job across the country to really maintain that uniformity in every state. This discussion, this particular issue in terms of crypto technology has been around. They have been discussing it and have been working on it, and this is now their final. Well, I wouldn't say the final form because there's always potential of changes and updating. I would say in the past years, I haven't. We would usually get all the UCC bills would come through us. We haven't had one in the last couple of years, and they're usually very huge pieces of bills like this. But it's a laying of the hands. You're not supposed to amend any of it. It's really, this is a standard form. One of the things you might notice, and Senator Bradley took charge on, was to put in effective date. This one's still January 1st, 2023, but I believe the bill that you guys had, you actually passed another effective date. Did you have another? 25. Okay. So in either way, what the issue was there is that generally they would prefer us to pass the 2025 effective date. But we want to put the legislation in statute because what happens is they want to ensure that anyone who's in the crypto technology world that is on board with this new statutory requirements. And so therefore the effective date, by pushing out the effective date, it gives everybody a chance to get their house in order, is the best way to describe it, to make sure that they are in conformity. And in terms of who this really affects is some financial institutions would be interested. The banking department was somewhat involved. But at the end of the day, I heard Senator Rosewall, you had a question about where this is coming from, and this is very important. This is really the key element of the issue, and that is it is not currency. It is not money. Crypto is actually a commodity. And the New Hampshire Banking Department, which has had some oversight in the past years, we more recently have kind of removed that oversight because it is not currency. And her, the woman who was in charge, she would always call them beanie babies, and that's the best way to think of them, as she said, think of them as beanie babies. So, not that that would be something that I would be promoting as the real what they are, but you have to think in terms of that these are not. It's not money. It's not currency. It is a commodity. And so this commodity is what we're trying to do, is how you handle the commodity, how it's dealt with in terms of trading, and that's what this statute would do. And I'll take some questions.
Senator Rosenwald.
A couple of questions,
Yeah.
if I could. You just said that this isn't about money.
No.
But on page 2 of the amendment, that's, I think, before 1616, there is a change to the definition of money. I wonder if you could explain that.
So where are you looking here?
Page 2,
Yeah.
starting on
Money. Okay.
line 14.
So that's if you're using money to buy crypto technology, the crypto block or whatever you want. I have to admit, I'm not the big expert on this issue, and Keith is, but in terms of that, buying that, there is, you could be using money to buy it.
But it's changing the definition of money.
I believe what you're seeing here when it says changing, that's crossing out the original bill as it came in. So, like I say, this is not on our books now. So unfortunately, I guess it would have been better if they wrote it in a way that. But I can't. I have to say that I probably want to use Securities Division is much more of an expert on this issue than I am.
Could we ask, because this is a replace all amendment, so I don't.
It does say
I think
replace
it
all.
must be
That's true.
amending current law rather than the bill.
Is there anyone here from securities?
They were out in the hall.
No.
Are
they're
they
right
here?
back
Okay,
there.
good.
If you could come up to the microphone, please.
Yeah, go.
Otherwise, people at home will not be able to hear you.
Yeah, so we have, we're under the Corporations
Can you
Division.
state your name for the record?
Oh, I'm sorry. My name is Kevin Moquin, and I'm a senior staff attorney with the Bureau of Securities. Under the Secretary of State's office, we have Corporations Division, Bureau of Securities. Unfortunately, we don't have the person who specifically handles UCC here. And I'm just looking at the bill related to your specific question, Senator Rosenwald, and it looks like what this does is ensure that the blockchain or tokens that are addressed by the bill are not defined as money under the statute. But beyond that, I'm not sure. I can tell you that our UCC manager looked at the bill and he said that or the amendment, I'm sorry, and he said that he did not have a problem with any of the changes that he saw.
Thank you.
Further questions? We have a cryptocurrency commission that has been established. How will this bill, should it pass, fit in with the work of that commission?
We aren't on the commission. We have attended the first meeting. And my understanding is that commission is going to be looking at a lot, kind of a broader area with regard to this. So I'm not sure it's going to have a direct impact. I know Representative Ammon is on the commission as well. So I'm not sure there's going to be any conflict of any sort. But I can't tell you that for certain.
Okay, thank you. Any further questions? Okay, seeing none.
Thank you.
Thank you very much, Kevin.
I did have another
Oh,
question for
okay.
Representative Hunt.
Okay, then we'll put Representative Hunt back up front.
Thank you. So yesterday I was reading about blockchain and the use of it, and I came across a very interesting article in the Harvard Business Review about Bitcoin mining, and I know this is not a Bitcoin bill, but it made the point that it's very computer intensive, and Bitcoin mining uses as much electricity in a year as the entire country of Sweden. And I'm wondering if in any of your discussions in the House, whether you talked about the unintended consequences of what might the impact be of encouraging these blockchain businesses to move into New Hampshire on our energy supply. Did that come up?
Okay, so we actually had several crypto bills. And I would say that, one of them was very scary because they wanted to create a whole new banking division. And I think some of that was geared to promoting the crypto technology and promoting it. I would say to you that what we're doing here, why this is the bill that the committee could get behind, is not about promoting it. It is about regulating it. Okay, and that is that we want to set the ground rules and how it is used and what it's done, and we want to have the same standard rules across the country. So how are interpreted? Clearly, I mean, some states, some countries have used it as a currency. I think El Salvador was going to take it as a currency, whereas China banned it altogether. So in terms of the public policy around crypto, that's not really what this bill is about. What this bill is about is how, because it is a commodity, because it is something, and it is something that theoretically someone could ask their financial institution to hold for them, that we want to make sure that we have the proper ground rules. And I can tell you, I would not have been in support of this bill if it wasn't the fact that this is a UCC bill. Okay? The UCC, I can't emphasize enough, that is the most important thing you have to think about what we're doing here, is that every state in the union is going to have this. And it's just, I've never, we have these UCC bills every couple of years, and like you say, they're just as many pages, and nobody ever thinks twice. And yes, this is true because we're enacting a new one, but at the end of the day, this is critical so that we, all the states, will have it. So whether we pass it now or pass it later, it won't matter in terms of how much, whether it's not trying to support the technology or support the idea. All we want to do is make sure we have proper guardrails. And I think you like guardrails. Wouldn't you like guardrails? Yeah, I would think so.
Can you put your microphone on, please?
Sorry. Would it be your recommendation that we change the date to 2025?
I would think that's probably fine. Yeah, that's probably a good idea. But we still want to pass it.
Mm-hmm.
Okay? By passing it, everyone knows it's there. It's in effect. The effective date would simply give, it gives cover because you don't want anybody to have be caught in a transaction that, which law is in effect, okay? So there is some constituents, people say, well, geez, if you wait, then someone might go, but I either way is fine. And, in terms of the UCC, right now, they're recommending the later date. And so I don't have a particular problem with passing the later date.
Senator D'Alessandro.
Thank you, Mr. Chairman. Maybe Representative Hunt can answer this, or maybe it's the securities people. But what securities law does this piece of legislation exempt these entities from?
I don't know. I don't think we're exempting them. I guess there is a sentence in here that will say specifically that it's not a security.
Okay, well,
That is in the statute. That is in this bill. In this UCC.
Mr. Volkman, can you address that?
Yeah.
It says the bill exempts the developer, seller, or facilitator of the exchange of an open blockchain token from certain securities laws.
Right, yeah. So what the bill does is to exempt the transactions so that transactions in this type of blockchain token are not considered securities. And it also, as I understand it, exempts dealers, people who transact in these specific types of tokens from the laws requiring registration as a broker-dealer. Originally, the bill said that they were not securities. Now they're exempt. So they can be considered securities on one level, but if they meet the requirements, then they're exempt. And that basically preserves our authority then to take action if there's fraud.
So, but does that exempt them from paying securities fees, transaction fees here in the state of New Hampshire, or do they just slide through?
Yeah, there's a $100 fee, I believe, that goes along with the filing they have to make with the Secretary of State's office, but they wouldn't have to pay the fee that would be required for a registration. And at this point, we haven't had any cryptocurrency or blockchain token applications for registration in New Hampshire, so we haven't had any at all.
Thank you, Mr. Chairman.
Thank you. Any further questions in committee? Thank you very much. Okay, so I think probably the first thing we need to do is to take care of the latest amendment on that. So I'll move the amendment, but with an effective date of 2025. Okay. And can you specify the amendment, please? 1616. 1616. But with a change in the effective date. Okay, so motion by Senator Rosenwald ought to pass on amendment 1616 S with change in the effective date to January 1st, 2025. That's seconded by Senator D'Alessandro. Senator Hennessy? Any further discussion? There being none, all those in favor of that motion say aye. Aye. Opposed, nay. Ayes have it, the motion carries. We're on to ought to pass as amended. Senator D'Alessandro moves ought to pass as amended. That's seconded by Senator Reagan. Any discussion? Seeing none, all those in favor of the motion say aye. Aye. Opposed, nay. The ayes have it, motion carries. Anyone interested in taking this one? Senator D'Alessandro. There we go, you got him.
Can't wait to ask questions.
And thank you to those who came in to give us a little bit of clarity on that bill. Let's go back to House Bill 275. Senator D'Alessandro moves ought to pass on House Bill 275. That's seconded by Senator Reagan. This is relative to the declaration of a state of emergency. Any discussion? There being none, all those in favor of the ought to pass motion say aye. Aye. Opposed, nay. The ayes have it, the motion carries. Senator Guida will take it out. Going on to House Bill 1431. It is establishing a parental bill of rights. Do we have a motion?
Move interim study.
Senator Reagan moves interim study on House Bill 1431. That's seconded by Senator Rosenwald. Discussion? Senator Guida?
I'm opposed to the interim study motion, Mr. Chairman. As has been discovered over the course of the pandemic, parents in many cases were unaware of subjects being taught, ideas and concepts being presented in schools. And what this bill did, originally in the House, it incorporated as well medical information and so forth. That was stripped out by the House. This essentially establishes that a parent is the person responsible for the upbringing of a child. The competition between school and parent is one that is dangerous, it's compelling, it's difficult, but at the end of the day, I think the parents have the right to know anything that's going on with their child outside the scope of perhaps, of abuse and those types of things, which are covered in law, and for which we have already a good body of law that protects that child from parents, if you will, if a parent is committing any of those offenses. And so for that reason, I will stand in support of a parent's right to know what's going on in schools in great detail. Thank you.
Thank you. Further discussion? I too will oppose the interim study motion for many of the reasons that Senator Guida has spoken. I think in this day and age it's important to outline and put in to the correct order the parental rights that belong to the parents. Further discussion? There being none, all those in favor of the interim study motion say aye.
Aye.
Opposed, nay?
Nay.
Let me see a show of hands. All those in favor of the interim study, raise your hand. And those opposed? And motion fails. Open for.
Move ought to pass.
Senator Guida moves ought to pass on House Bill 1431. Is there a second? I will second. Discussion? Thank you. Senator Rosenwald moves amendment 1930S. And you're recognized.
Because this is the finance committee, not the policy committee. We're the finance committee, not the policy committee, so I've looked at this bill primarily through the lens of cost, and I'm concerned about the impact of a confusing open-ended bill like this on our local school districts. I think it will lead to litigation, and so I'm concerned about the cost that will be put on property taxpayers. And I'm also concerned about the impact on our court system for litigation. So this amendment, which requires the Department of Education and Health and Human Services to put all of the current statutes relating to parental rights on their websites, it strikes the cost from the bill. And essentially, we're looking now at staff time to prepare a PDF and publish it to a department website. So I think that it is fiscally responsible. And I didn't vote for the underlying bill.
Thank you. Discussion on the amendment. Senator Gaida.
Yeah, I'm in opposition, Mr. Chairman. This amendment skirts the issue. That's the core, it lies at the core of this bill. It also establishes a sort of precedent to state that a parent's rights can be defined by an agency or a bureaucracy. Not so in my world. A parent's rights are ordained by the Creator. They are amongst those things that we consider to be inviolable, not definable by public policy, but definable by a higher standard. And for that reason, I will oppose this. Again, our rights don't flow from agencies or the state, and this bill clearly defines. With respect to litigation or open-endedness, the bill is painstakingly clear in defining what those rights are, and equally establishes, I think rightfully, consequences for violating those parental rights. I don't think that's a problem. One of the problems we do face in our state is the plethora of laws that have no consequence for being broken by state agencies or state employees. This bill very clearly articulates those rights. It articulates a remedy if those rights are violated. And again, I don't see that as a liability. I see that as a contributing benefit to the future of parental rights. Thank you.
Thank you. Further discussion? I have a question for Senator Rosenwald. You mentioned, if you took all the statutes that were necessary regarding parental rights and such, do you know how thick that would be if it was put on paper?
I'm sorry, but I do have 4 pages of typewritten notes on what is confusing and unclear in the bill.
Okay, so I'm going back to the statement you had before, looking at the money side, because on your amendment, you talked about making it available on the website, but there's also a statement that you'd make the guidebook available to the public in paper copy. And if all the parents decided that they wanted copies of this, but they wouldn't, but that's why I was asking if you have any idea how many statutes.
I don't, I'm sorry, but I would be willing to believe that court case would be more expensive. And I see that there's a representative of the court system here who perhaps could talk to us about the cost of litigation.
Okay, and my final comment is that in the fiscal note, the branch, meaning the judicial branch, assumes that if the bill is enacted, there would be an increase in criminal complaints, which goes to the point of an indeterminable increase. So we don't really know. Any further discussion?
Could we hear from the representative of the courts? Mr.
Sure,
Head
if
is
you have
here.
a question for them.
Good afternoon. Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. Thank you. Actually, do you want me to speak or do you want me to answer a question?
Well,
I have a question. Go ahead.
when you looked at the bill, what kinds of costs was the judicial branch looking at that were indeterminable?
So thank you for the question. After the Senate amendment occurred, which the fiscal note has not been updated, it would not be a criminal pleading anymore. It would just be civil cases that would be presented under the appeals section of the bill. So any parent who has not been able to get the relief that they've wanted from the school system would have a right to a civil appeal to the Superior Court. So that's one type of case that could be brought by a parent, and then there's an appeal to the Supreme Court. In addition, I think there would be some litigation in the family division when we're talking about parental plans, or where we're talking about the authorities of orders that have been issued from courts. So in the first part of it, I think we're going to see an increase in litigation in the family division where one parent is concerned about the other parent's access to these records. And we're going to see in parenting plan litigation whether or not there are specific changes to plans that are requested in order to either limit or expand the authority of a parent to access the records that are outlined in this statute. The other aspect of it is what types of orders can be issued by the court that would override the authorities that are issued, the rights that are outlined in this statute. So for example, a protective order can be issued under 169C, which is specifically referenced in the exceptions on page 4. But what happens, and that's Child Protective Act, what happens with a domestic violence order where the victim of domestic violence is living with a child in a protected environment, in a confidential location? What would be the authority of the other parent to obtain records that are specifically outlined in the statute? We may see litigation over that. Or if it's a criminal bail protective order that's been issued, it's not issued under 169C, would there be additional litigation or protective motions filed with the court in order to limit the authority of an abusing or the person who is subject to a protective order not under 169C to be able to either limit or gain access to records that would be in the possession of the school district. So I think you would see, get to your question, litigation that is sort of directly described in the bill, which relates to appeals by parents who are unable to get the relief they think they're entitled to under the statute and seeking an injunctive order and costs from the court in the Superior Court. Or we may see litigation in the family division that relate to parental orders. And then third, we may see litigation in either Superior Court or Circuit Court relative to other protective orders not issued under 169C.
Okay, are there further discussion on the amendment, which is relative to publishing a parental rights guidebook?
No, I had a question on the underlying bill.
Okay. Regarding the amendment? Senator Gaida?
Yeah, again, I think that the absolute pure conjecture, any law this body ever passes is subject to possible litigation, indeterminable. And so I think it's a specious argument to try to quantify some indefinite possibility in terms of cost. And that includes the cost of producing these books. We don't know how thick they're gonna be, but if you looked at the administrative procedure for schools, it's about 6 inches thick in fine print, both sides of all pages. So somewhere in all of that, I'm sure some delineation of parental rights. It's an indeterminable increase that could be formidable, especially given the cost of printing. Thank you.
And relative to where I was, that is why we have indeterminable in our fiscal note. It could be one lawsuit, it could be 1,000, and we just have no numbers to be able to quantify it.
Thank you. Any further discussion on the amendment? There being none, the motion is ought to pass on Amendment 1930. All those in favor of that motion say aye. Aye. Opposed, nay?
Nay.
And the motion fails. Senator Rosenwald, well, let's get a motion first. I think we had an ought to pass well, we're back to the ought to pass motion, and Senator Rosenwald, you are recognized to speak on the underlying bill.
I had a question of Mr. Head.
Mr. Head, moved away too fast.
Thank you. In the Superior Court in civil cases, what is the average length of time between the case filing and when that case is scheduled?
Short answer is I don't know. This would be a request for injunctive relief. Assuming there's a request for preliminary injunction, that's quicker. So I don't know sort of the average time on injunctives. I did not research that question ahead of time.
Thank you.
Okay. Any further discussion on the bill? Senator D'Alessandro.
Thank you, Mr. Chairman. Mr. Head, maybe you can answer this. The bill, in the corpus of the bill, page 1, lines 5 and 6, it talks about important information. Who ascertains what is important information? And how is that, who decides that, and who gets this important information? I've been a teacher and a coach, and there are many times a student or a player who's playing for him will say something, and it's important because he or she took the time to say it to me. But indeed, do I have an obligation to then give this important information to a parent? And who decides that?
So thank you for the question. I think that, those are the types of questions that would get raised in those petitions for injunctive relief, where a school district has taken a position relative to information in its possession, and a parent thinks that either the school would think the school is interpreting that too narrowly. It would get resolved in litigation on sort of a factual basis.
One further question, Mr. Chairman. In primary schools, K through 5 and K through 8, they start the morning off with morning meetings. Just put the kids in a circle and the kids talk. There are many times things are said at those morning meetings by a youngster. Who decides whether these things are so important that they have to be relayed, to a parent? I find that to be, excess in terms of this situation. And
So without sort of taking a position relative to the bill itself, I think there are probably two answers to that. One is that in developing the school policies, some of those definitions would be developed within the school policies. Those policies themselves may result in litigation as they're being defined. And then secondly, as requests are being made to the school districts, within those policies, that may result in further litigation. With all statutes, they are Where there are ambiguities, they tend to get defined by a court eventually down the road. Legislature then evaluates whether or not it agrees or disagrees with the way the court interpreted that. So I think in the first instance, you would see it in the policies from the school districts. You would see litigation over those policies. And then as requests are being made or as the sort of action that's required under the statutes occurs, you would see potential litigation with further definitions.
Just one further question,
Oh.
Mr. Chairman. The idea of the school situation is to teach. It seems to be what you're deviating from is that time that's spent teaching the youngster with all of these situations that are in place. And I see the ultimate situation is to discourage people from getting into the teaching business. We have a tough time finding teachers now.
And outside of the scope of
Yes.
certainly what I'm prepared to talk about today.
Right? Well, thank you. Thank you, Mr. Chairman.
Senator Gaida?
Thank you, Mr. Chairman. With respect to Senator D'Alessandro's concern about important information, I would note that that's under the declaration of purpose in this legislation, that the actual language of the bill itself is very clear and very specific in those things that are required. With respect to important information, I would, with a sense of humor perhaps, refer us back to one of our U.S. Supreme Court justices when asked to define pornography, could not, but he said, "I'll know it when I see it." And the same thing, the important information is spelled out here, and I think we trust our teachers with judgment enough to know when something rises to the level that a parent ought to be told. I don't think parents are unreasonable. I think that parents have grown increasingly concerned over the expose of what's being presented to their children in schools. And so I also don't think parents are necessarily combative. They would like to see a resolution at the local level without having to resort to courts. But if a school is intransigent, then the remedy is there for the parent to pursue a remedy in court. Thank you.
Thank you. Further discussion? Motion before us is ought to pass on House Bill 1431. Ready for the vote? All those in favor of that motion say aye.
Aye.
Opposed, nay.
No.
And motion carries 4-3. And Senator Gaida?
Sure.
Okay, going on to House Bill 1476. This is relative to the release of a defendant pending trial. Senator Gaida moves ought to pass. Is there a second? I will second. Discussion. Yes. That's okay. Made me feel better. This is if somebody is, someone has been arrested, they're pending trial, they're released, they go out, they commit another crime, then they're held after that. Any discussion? There being none, the motion before us is ought to pass on House Bill 1476. All those in favor of that motion say aye.
Aye.
Opposed, nay. Was there a no? Or did, everyone was aye? Okay. Would someone like to take that out? What's that? It was 7-0.
I'll take it.
Senator Gaida? Going down to House Bill 1548.
Who ought to pass?
Senator Gaida moves ought to pass on House Bill 1548. This is relative to the sale of the Lakes Region facility. Any discussion? Seeing none, all those in favor of the ought to pass motion, say aye. Aye. Opposed, nay. The ayes have it, motion carries. Senator Hennessy, thank you. House Bill 1661. We did 1587 already. Yes.
I'll second if you hadn't seconded.
Okay, who moved? Senator Hennessy moves ought to pass, as seconded by Senator Gaida. Discussion. This is relative to the regional career technical education agreements and relative to an appropriation for preliminary work for a new legislative parking garage. Seeing no further discussion, all those in favor of the ought to pass motion say aye. Aye. Opposed, nay. The ayes have it, the motion carries. Senator Hennessy, thank you. And House Bill 1677, and I'm going to recognize Senator Morse for a statement.
I'd like to move up pass.
Okay, Senator Morse moves ought to pass on 1677. That's seconded by Senator Reagan. Discussion.
Well, first,
Senator Morse.
I'd like to recognize all the work that was done in the House and with the AG on this bill. There's been decades of abuse that have happened at the Youth Development Center, and it's appalling. The investigation that the Attorney General is conducting is necessary and essential to ensure that those responsible for this abuse are held accountable and that justice is served. There are currently hundreds of civil lawsuits brought by former residents of the YDC, and the Senate is taking this matter very, very seriously. The $100 million fund that is established in this bill is unprecedented in New Hampshire's history and reflects the importance that the Senate is placing on making sure that the victims are compensated for their suffering while in state custody. Let there be no doubt that we are going to do the right thing by these people. Moving forward, it is the Attorney General's role to work with the plaintiffs and their attorneys to determine an appropriate process and fair settlement of claims. The plaintiffs and their attorneys know the most about their side of the case, and the Attorney General knows the most about the state side of the case. They are the parties that are best able to determine a fair resolution. We fully expect an agreement will be reached that compensates victims' families and with the decency and respect that they deserve. It is our hope that this legislation will provide a step forward to a resolution of these tragic cases that have affected so many people. Mr. Chairman, my firm belief that the bill that the House passed is the bill the Senate should pass. I think the Senate should send a strong message that we support getting settlements on this, and I think the work that's been done on it is to get to that point.
Thank you, Senator Morse. Motion before us is ought to pass on House Bill 1677, open for amendment. Senator D'Alessandro.
Well, I'd like to speak to the bill before Senator Rosenwald and I have a couple of amendments. I think in its current form, Senate Bill 1677 is incomplete, it's inadequate. It's an inadequate response to the extensive and horrific abuse of children that was allowed to take place for decades at the Sununu Center. I don't feel that the definition of sexual abuse in the bill adequately captures the atrocities we understand took place at the Sununu Center for decades. The bill as written will not ensure that all victims can access this process. And the whole point of this bill is to ensure that, to the extent we can, the state is making these people whole. The Attorney General, we have great respect for the Attorney General. I think he does a great job, but he has to have two roles. He's got to prosecute and he's got to defend. That's difficult to do. It's difficult to do under any circumstances. He's got to take care of the state, and he also has to serve the victims. Highly, highly problematic. I don't find that this bill to be victim-centered or trauma-informed, which should absolutely be our overarching goal. While I'm disappointed that I can't support this legislation as written, my vote today is on behalf of these victims who were horrifically abused as children. I can't fathom the pain and suffering that they endured, and this is simply too important not to get right. Getting this right is so important. I think of what happened in other states around the country where they didn't get it right, where they found graves, shallow graves of children who were abused in different states around our country. And who got remission for that? Nobody. We will do it better, and I think we can do it better. Thank you, Mr. Chairman.
Thank you. Any further discussion? Senator Rosenwald.
Thank you. I'd like to move Amendment 1910S and speak to it.
Senator Rosenwald moves Amendment 1910S. Is there a second?
I'd second the amendment.
Second by Senator D'Alessandro.
Thank
Senator
you.
Rosenwald, you recognized?
Thank you. So this amendment makes changes to the underlying bill that have been recommended by the country's largest nonprofit child protection advocates. So it is not bringing ideas from any of the attorneys who are representing any of the victims here. But the first thing it does is broaden the definition of sexual abuse. We have about 6 different statutes that refer to the criminal code for sexual abuse. But the way the bill is written, it requires physical sexual contact between an adult and one of the incarcerated children from the SYSC. So what it doesn't cover, for example, is the staff masturbating in front of a child and forcing them to watch. And I think any one of us on this committee, if that was our child, we would be outraged that that was not included in the definition of sexual abuse. I just don't think that's appropriate. I don't think that's what we as 7 caring individuals think, and I don't think it's the right public policy. If one of the staff made children shower together and photograph them doing it, that's not covered either. And I don't think that's where we want to be. So this amendment broadens the definition of sexual abuse to include these other criminal offenses. In 649, for example, 645, because I think they reflect our values. The next thing it does is it lifts the cap on cases from $1.5 million to $2 million, which in a review of national cases of child sexual abuse seems more reasonable. It also it strikes out the language about false claims. It is already against both criminal and civil law in New Hampshire to file a false claim. So we're talking about people who have already been victimized. If they're on another threat of, oh, if I don't believe you, I'm going to call the police on you, it's chilling, and it's likely to intimidate someone and prevent them from even filing. And the last thing it does is removes the required waiver in the bill of pursuing additional remedies. So if you were under this bill, you could seek settlement if you were actually raped, but not if you were forced to watch an adult masturbate in front of you. You would not be also able to go to court to pursue that claim. And I don't think we want to write off the horrible and very real damage that was done to children over decades in the care of the state. So that is what this amendment does, and I hope you will agree with me.
Thank you. Because we are in the middle of litigation, and I find it inappropriate for legislature to get involved in a case in which we do not know the facts on either side, facts that should be worked out between the Attorney General and the plaintiffs, I will be voting against this amendment. Any further discussion? Senator Rosenwald.
Yes, just to say we are already involved because we have a bill before us. There's never been a legislatively created settlement. This would be the first. They've always been done by either Congress or by the court. So the legislature is already involved here.
Further discussion? Senator D'Alessandro.
Thank you, Mr. Chairman. I support the amendment, and I think Senator Rosenwald has made the points very well to everybody here. All 7 of us know about the tragedy of the Sununu Center. We know what happened there. There are over 500 cases before us as we speak. Over 500 cases. Some people have died who were involved. They'll never have their cases resolved. The amendment addresses all of the victims and addresses all of the crimes. And I think all of us, after hearing this, have to feel that the real terrible situation that our state allowed to happen. Our state, that's a state institution. Those children were being supposedly protected by the state. This situation happened in other places, but not dealt with properly. We're trying to do a better job of dealing with this and respecting all of those whose lives were altered terribly by this situation. And with regard, I have great faith in the Attorney General. I think he's terrific, but he's doing both. You know, he's got to defend the state. He's got to protect us. On the one hand, he's got to deal in terms of those who were aggrieved. That's a difficult situation. How do you do that? It's very difficult. I think the amendment's a good move in pushing us forward. Thank you, Mr. Chairman.
Any further discussion? Seeing none, we're voting on the amendment. 1910S. All those in favor of that amendment say aye.
Aye.
Opposed, nay. Nay. The motion fails 2-5. Open for further amendment.
Thank you. I'd like to move amendment number 1921S and speak to it.
there a second?
Second.
Second by Senator D'Alessandro. Senator Rosenwald, you're recognized.
Thank you. This amendment changes only the funding source of the settlement fund from suspending the statute on the rainy day fund 913E to be the primary source of funds being the current reserves. I asked LBA yesterday what our surplus looks like versus what the commitments of bills before the legislature is. And through April, we are running 350 million ahead of plan. And as of the time we started in here, there were requests for 270 million. We didn't pass the stipend, so that takes it down. So let's say there's $90 million of surplus currently available to us. I think it is fiscally irresponsible to take more than a third of the money out of the rainy day fund, which we have worked really hard since the last recession to restore. And I think we all saw a letter from the state treasurer who pointed to what could lead the rating agencies to downgrade our bonds. For Moody's, major erosion of reserves or liquidity. Fitch, adequate rainy day fund reserves. We're still not at our statutory limit, but in a current environment where the cost of borrowing money is increasing, I think taking more than a third of the funds out of the rainy day fund when we don't have to would jeopardize our ability to continue economic expansion at good interest rates. So I hope you will agree that this is a more responsible approach. Thank you.
Thank you, Senator D'Alessandro.
Thank you, Mr. Chairman. I've asked the treasurer to be here to comment. Is that appropriate?
Sure.
Treasurer, I read the treasurer's letter that was given to the to the members of the Senate committee that dealt with this, and I too am very concerned. If we have money at this point in time, we're running revenues way beyond what our expectations were, and why should we take money out of the rainy day fund? The idea of the revenue stabilization account is if there's a problem, you go to the revenue stabilization account, but you have to show a deficit in order to do that. And we did it one time. And one time in my legislative career, we went to the rainy day fund for $70 million because of the fact that we were in a deficit situation. So I ask, may I, Mr. Chairman, the treasurer to comment, please.
Good afternoon. Thanks, Senator Alessandro. For the record, State Treasurer Monica Mazzapelli, and that's correct. I think what I can add to this discussion is the fact that the revenue stabilization account is established in statute for that one reason, for when there is when there's a deficit. So then there is a mechanism to tap into that fund for those situations. That's widely known. Every state, every issuer, hopefully every household has some sort of emergency fund that could be used in cases where there's an economic downturn. And those are the times when obviously having reserves will benefit any state. The rating agencies see that as a mechanism to use. So clearly maintaining enough reserves and the rainy day fund is obviously prudent and well accepted. Again, the summary that I put together, I was able to share that with the Judiciary Committee, was that summary that the rating agencies, they prepare reports. The last time they evaluated us was in March of 22. one of the rating agencies changed the state's outlook from stable to positive due to all the various, facts that we were able to show them and be able to, support the fact that New Hampshire has a strong economy, was able to have a swift recovery after the pandemic, and in all of those points, in addition to having adding funds to the rainy day fund, allow for that outlook change. Again, that rating agency also described the steps that the state could take in order to get an upgrade in the future, but also also the steps are there. If the state went to go back, then obviously the outlook for the state could change negatively. So that's what I can add there. The reason why it's important to have a strong rainy day fund, obviously, is again, to show investors that the state will be able to weather, a future recession. Unfortunately, we're hearing a little bit about that noise right now, as you probably hear in the news, with the Federal Reserve trying to control inflation. Experts are not clear whether the Fed is going to be able to manage that in a way that is going to be smooth for the economy. The point of doing this is to actually slow down the economy and to be able to control that inflation. But experts are a little concerned that the Fed will not be able to handle that the right way, and we perhaps will see a recession. It's unclear. It's not that I'm predicting a recession. I'm just hearing, and again, that's the noise out there. And so going to Senator Alessandro's point, yes, we've seen strong revenue coming in this fiscal year. It looks like right now it's about $350 million above plan. So that could be, again, a possibility if the funding were to change. I'm just gonna state this. I don't take a position on the bill. My only objective and objective for today is to just provide you with the information that you perhaps could use to make the policy decision, regardless of what you choose to use the funding that you choose to use. It's again, my intent is not to provide comments about this legislature. This is this legislative initiative. This is an important bill, and so I just want to provide information about the funding.
Senator D'Alessandro.
Thank you, Mr. Chair. But your job as the state treasurer is to advise us as to prudent practices with regard to the investment of our funds, and to give us a clear path to follow. And clearly, the revenue, from my perspective, the revenue stabilization account is just that. When you see a negative financial situation, a deficit, you call upon this legislature to go to the revenue stabilization account. I was here when we went to the revenue stabilization account for $70 million. We had a deficit. We don't have a deficit now. We have a robust situation. We are exceeding plan by about $300 million at this point in time. So as interest rates are beginning to rise, are they not? There is uncertainty being forecasted. So as our treasurer, what kind of advice do you give us vis-a-vis the revenue stabilization account? And just a business from the standpoint of managing the business of the state. What do we do?
Thank you, Senator. That's a difficult question. I know finding $100 million is not easy, and I've shared this information with you. And again, I feel like my job is to share, the potential ramifications of using this funding. We discuss, the state's financial conditions with the rating agencies. So we do that every time They want to know how we're doing, and every time we issue bonds. The policy decision is yours. There is funding, there's surplus, but I just want to, again, mention the fact that the rainy day fund is seen as a very important. It may appear to be another dedicated account with funding, but in reality, in the eyes of investors that want to, again, invest in the state, the rating agencies that try to verify creditworthiness, in the eyes of those folks that are looking at us, tapping the rainy day fund for something other than a budget deficit, might look, again, we may need to explain it. And if that's the case, if the legislation includes this funding, we'll provide an explanation as to why the state decided to go that way. But in the eyes of investors, again, and the rating agencies, they may not understand it right away. But again, we will provide that information as is requested. Again, I understand it's not easy to fund $100 million for this initiative or any other initiative, but tapping the rainy day fund again could just bring ramifications for the state.
Thank you. Senator Hennessy?
Thank you, Mr. Chair. Thank you, Madam Treasurer. Can you tell me, time-wise and I guess theory-wise, if we're running at 350 ahead right now, and we're going to be spending probably about 250, that leaves us with $100 million that would go into the rainy day fund. So semantics-wise, what's the difference and what's the timing difference? And would anyone really notice that there was $100 million that went in, there was $100 million that went out?
They will notice, that's for sure. So the money doesn't go right away into the rainy day fund. So if you have a surplus this year, it will stay in the surplus account, and it will go. And again, it will still have fiscal year 23 activity to see how that budget, that budgetary activity happens. And at the end of the biennium, that's when any surplus goes into the rainy day fund. Or that's when, if there's a need to tap into the rainy day fund, that's when you will do it after the audit is all completed. In the meantime, everyone is just observing the state, observing the financial activity, the financial results of the state, and again, it's just the mechanics. Some other states have a clear fiscal year, and for us, our budget is a biennial budget.
Thank you. So if it happens that we're not 350 ahead by the end of this of June 30th this summer, this amendment says that anything not available would come from the rainy day fund. So how does that? Is there a threshold of a dollar amount that would affect the ratings?
I have not read the amendment of the bill. However, to answer your question, just it's hard for me to say that. I think part of what was provided in the summary is if significant funds are taken from the rainy day fund, that's when it perhaps would create negative consequence. The reality is, we will every time we're reviewed. That's when the rating agencies will evaluate, the state's policy, I would say. So again, one of the things that was praised about New Hampshire last time they reviewed us, it was the fact that the state decided to increase the cap. So a credit positive, something that is considered, that is viewed as a good thing for the state, adding more money. But if the state does something that might not look like is something that it will to improve the state, they might consider in a different way. So it's not clear there is a threshold. All I know is that the statute is clear as to how the mechanics work. It is, if at the end of the biennium there is a budget deficit, that's when it's okay to get money from the rainy day fund. And we have plans to use that in fiscal year 20 when we had the a deficit was projected. We were issuing bonds at the time. We explained to rating agencies we may need to use about 40 million, I can't remember the exact amount, but that was not something that caused them a headache. It was just understood, yep, that's what the state will need to do, that's what other states did, and no one got downgraded. And again, it's just how the state, it's just to prove how this, the state's policy position. But again, if the state chooses to fund this a settlement fund with the rainy day fund, again, we'll just find a way to describe and how to explain, why the state decided to create that policy.
Thank you.
Any further discussion? Senator Rosenwald.
Thank you, Madam Treasurer, for being here. If I were an investor considering buying New Hampshire's bonds, but I were looking at some other states of our relative position, taking more than a third out of our reserves, would that put New Hampshire possibly at a competitive disadvantage to other states? If I were an investor?
Perhaps, and so we deal with the underwriters, the firms that buy those bonds for, our bonds, and then they sell it to individual investors. So if the state gets, a change, if the rating agencies decide to change New Hampshire's outlook from stable to negative or from positive to stable, that's an indication for those investors to say, well, there's something here that we need to consider. That could possibly put us at a disadvantage, perhaps the pricing, or perhaps they won't offer, we're looking for the best yield. They might not offer the best yield. But, New Hampshire has been so fortunate. It's investors usually want to diversify. We don't issue bonds like many other states. We issue typically once a year. So right now, as of right now, we've always been received very competitive yields and interest rates offers. But it is possible that if the outlook changes, then investors want to probably learn more about as to why. And again, we publish all of that information. We need to disclose any changes, any significant changes, material changes that the state decides to do. So perhaps something like that, changing the amount of the rainy day fund, perhaps something that we need to disclose to investors so they know. Again, they want to know what our state is doing.
Senator Guido.
Thank you, Mr. Chairman. Simply put, if at the end of the day, the state's running a deficit because of some huge legal settlement for YDC, right? If we have a deficit, we can tap the rainy day fund, and that would not raise too many eyebrows, but we're not starting to fiddle with the mechanisms of putting money in and taking it out for specific purposes. We're just going to use the deficit, and that would be the normal course of business. Is that correct?
That is correct.
Thank you.
Any further discussion? Senator Morse.
Well, if the treasurer's through, I'll speak, but I don't have questions for the treasurer.
Okay. Thank you.
Thank you.
Senator Morse, you're recognized.
Yeah, and I would like to thank the treasurer for bringing this to me because, like she said when she came to me, that's an obligation she has. I certainly have been here long enough to know the treasurers have sat in with me and said that we are doing great when I ask questions about Wall Street and what the state's position has been. The House passed this bill with this coming out of the rainy day fund. The executive branch will support it coming out of the rainy day fund. And the message that would go to Wall Street is that we all agreed to this coming out of the rainy day fund. We certainly didn't know we'd get to $350 million. I'm hearing that it might be greater than that by the end of June. We've spent 271 minus 11 today. I don't know what will happen to that on the floor on Thursday, but we know where we are. But beyond that, we have 18 to 20% vacancy rates in the state of New Hampshire. Where do you think that money goes? This money is scheduled to come out in October of 22 and go through a process till June of 23. You, at the end of June in 23, will have 18 to 20% lapse because of just vacancies, not counting anything else. You'll have 123 million that was predicted that we're gonna be over in revenues next year. And you'll have probably well over 100 million coming out of this year. Where does it all go? I think it was the responsible way to do things. I think agreeing with the House means this bill leaves the Senate floor on Thursday and goes to the governor's desk. And that's where it should go. Because the statement to these kids that we're in that horrible situation should be that we care as a state of New Hampshire and we're gonna start a process. That's what should happen on Thursday in the Senate. And that's what should go to the governor's desk. I think it should stay right where it is. I think the governor's willing to defend that with Wall Street, along with fighting with the treasurer to defend it. I don't think there's even an issue, to be honest with you. Thank you.
Any further discussion? We have the amendment 1921S before us. The motion is ought to pass. All those in favor of that motion say aye. Aye. Opposed, nay? Nay. The motion fails 2-5. And we're back to the main motion of ought to pass on House Bill 1677. Any further discussion? Senator Rosenwald.
Thank you. I think the message we're sending to the 500-plus individuals who were sexually abused over decades, first at the YDC and now at the Sununu Center, is that we really don't care that much about what happened to them. So I'll be voting no.
Any further discussion? Senator Morse.
I just want to make it perfectly clear, that's not the message coming out of the Senate that I'm president of. This started with the governor saying, with a strong statement, that he wanted to solve a problem. The House passed something that we can respect as a Senate, and the message we're sending is we want to solve the problem. And I want to be clear about that.
Further discussion. Senator D'Alessandro.
Thank you, Mr. Chairman. Mr. Chairman, I'm disappointed that I can't support this legislation. I think everybody knows people want to do the right thing. And I support that, I approve of that. But my vote today is on behalf of those victims who are horrifically abused as children. I can't fathom the plan, the pain, the suffering that these people endured. And it's so important that we get it right. We've got to get it right. Right for those people, right for the state. And I think we had a way to do it, and we just didn't do it. I was a trustee at the old Youth Development Center from 1974 to 1980 when I was on the Executive Council. And some of those things must have been happening there. Meldrum Thompson was governor. His wife was a trustee also, who worked very hard to get things done at what was then the Youth Development Center, now the Sununu Center. We've got to get this right. It's so important that we get this right on behalf of those children, men and women who were just so terribly treated. And if we don't get it right, others are going to see this. This is a national situation. You know, this isn't something that's just New Hampshire. The whole country's looking at this. And look at the way others were treated. They missed the boat. We got a chance to be there doing the right thing. Thank you, Mr. Chairman.
Senator Gaida.
Thank you, Mr. Chairman. I am 100% certain that I speak for every member of this committee with respect to the reprehensible, horrible, disgusting things that took place in Sununu. We are in a difficult position because just as we decry the court stepping over into the bounds of legislative activity, okay, we also have to constrain ourselves, and sometimes very difficult to do that, from interfering into something that is in the purview of the judicial system. This is one of those cases. I'm not an attorney. I don't for a second believe that the intent of this legislation as presented can possibly be misconstrued. There's certainly no intent to exclude anyone, or any class, or any person that was aggrieved by the horrific acts that took place. But just as with decisions this body has made with respect to interfering in the St. Gobain issue, where litigation is ongoing, and contracts and so forth, we have declined to act as a legislature involved in litigation activities. And so in this case, difficult though it might be, I believe that the intent of this law is perfectly clear, not to exclude anyone that was aggrieved by any of the disgusting things that took place there. I also believe we have to be very careful constitutionally to start inserting the legislature into legal settlements. Thank you, Mr. Chairman.
Thank you. Senator Rosenwald.
Thank you. Well, I'm not a lawyer either, so I can only look at the bill, and I can only look at the plain language of the bill, but it excludes sexual criminal offenses on purpose because somebody wrote this bill that I think the 7 of us would agree should not happen to anybody and should particularly, well, it's not even worse that it happened to children in the state's care. But I'd say that the intent is to exclude those crimes because the bill was written excluding them. And so it will be the legislature's intent and the Attorney General's intent and the governor's intent to exclude criminal sexual offenses against children that we would go nuts if it happened to any of our kids or grandchildren. So I think it is intentional because that's the way the bill is drafted. Thank you.
Any further discussion? Motion before us is ought to pass on House Bill 1677. All those in favor of that motion say aye. Aye. Opposed, nay.
No.
The motion passes 5-2. And I'll take that one. Okay, is there a motion to come out of executive session? Moved by Senator Gaida, seconded by Senator Rosenwald. All those in favor say aye. Aye. Opposed, nay. Ayes have it, motion carries. And I want to thank the committee for the last 2 years. We've had good debates. They've been respectful. I've learned a lot, and I really appreciate the wealth of knowledge that each of you have on your respective areas of expertise. And I want to thank Deb for keeping us organized. And so this does conclude our business. Senator D'Alessandro, you recognize.
Thank you, Mr. Chairman. I've had the opportunity to serve with you twice as chairman, and I commend you for the decent way you handle the Senate Finance Committee. You're courteous to everyone. You allow everybody to speak, appropriately so, and I commend you for that. It's a pleasure to serve with you. It's an honor to be a member of the Senate. It's an honor to serve with you. So thank you very much for all of your work.
Thank you.
Appreciate it.
Senator Rosenwald.
I'd like to echo the Dean's comments and also extend our thanks to the LBA, who,
Yes.
as always, just
And not only the LBA, but everyone who comes in here on a regular basis and calls this their second home. And then Senator Hennessy, we wish you well going forward, and thank you again for your contributions. And Senator Gaida, you as well. Thank you. There being no more business, we will be adjourned. Thank you.